Shocking courtroom win. A federal judge poised to undo hundreds of job cuts from the chaos of the government shutdown. But is this fair play? Imagine losing your job not because of poor performance, but due to a bureaucratic tangle during one of the longest government shutdowns in history. That's the reality for hundreds of federal employees who were laid off amid the turmoil. Now, in a major twist, a federal judge in San Francisco has signaled she's about to reverse those terminations, breathing new life into these workers' careers. But here's where it gets controversial. Does this uphold the rule of law? Or is it an overreach that could complicate things further? Stick around to dive into the details of this unfolding drama. Federal employee unions, including the American Federation of Government Employees and the American Foreign Service Association, took the bold step of petitioning the court to overturn layoffs at key agencies like the Department of Education, the Department of State, the Small Business Administration, SBA, and the General Services Administration, GSA. These organizations had issued reduction in force, RIF notices, think of them as formal warnings about job eliminations, to staff members before the recent government shutdown hit. For many, the actual separations were set to happen in October or November, right smack in the middle of the shutdown period. The union's argument was straightforward yet powerful. These agencies broke the rules by finalizing the layoffs during the shutdown, defying a temporary spending bill from Congress that barred such actions through January 30, 2026. This bill, known as a continuing resolution, acts like a financial lifeline to keep government operations humming when full budgets aren't in place. And this is the part most people miss. It's not just paperwork. It directly impacts real people's lives, from diplomats abroad to civil rights advocates at home. To give you some context for beginners, a RIF is essentially a process to cut jobs when an agency needs to downsize, often for efficiency or budget reasons. During a shutdown, funding freezes mean agencies can't always proceed with such moves, which is where this legal battle heats up. Earlier this month, the court issued a temporary restraining order, effectively pausing the layoffs of nearly 250 Foreign Service officers at the State Department. Originally slated for November 10th, these were delayed to December 5th, and now they're in limbo. The Trump administration, however, has taken a more limited approach to the spending bill. They've only brought back employees who got RIF notices between October 1st and November 12th, leaving others in uncertainty. Let's break down the continuing resolution a bit more to make this clearer. This bill, passed by Congress on November 12th, explicitly states that no federal money can be used to start, carry out, or notify about reductions in force from November 12, 2025, to January 30, 2026. It also declares that any RIF actions proposed, noticed, or executed between October 1, 2025, and the bill's enactment date are null and void. In simple terms, Congress drew a line in the sand to protect jobs during this volatile time. For example, imagine if your local school district tried to fire teachers mid-budget crisis. This bill says that's off-limits. In a recent hearing at the U.S. District Court for the Northern District of California, Judge Susan Illston made her stance clear. She plans to approve the union's request for a preliminary injunction because the chaotic nature of these RIFs has been continuing. She pointed out that the resolution, which ended what was then the longest shutdown ever, forbade using federal funds for layoffs through January 30th. Yet some agencies went ahead anyway. That is not what is happening in some of these agencies, she remarked, highlighting the disconnect. The judge's decision could affect around 680 federal workers in total, including those 250 Foreign Service officers at State, about 200 at GSA, roughly 150 in the Education Department's Office for Civil Rights, and nearly 80 at SBA. She's yet to release the written preliminary injunction, but during the hearing, she expressed openness to a short delay from the Justice Department to give the Trump administration a chance to appeal to a higher court. This would help avoid the whiplash employees have experienced in past cases, where lower courts reinstated them, only for appeals courts to allow the firings to proceed. They'd have to send a notice and then another notice and a notice saying, "Forget what we said yesterday." It would be terrible, Illston said, painting a picture of the emotional roller coaster these workers face. Brad Rosenberg, a Justice Department lawyer for the Trump administration, argued that undoing the layoffs now would create logistical nightmares for agencies. If the decision gets overturned later, they'd have to restart the whole process from scratch, like trying to unscramble a broken egg, as he put it. That's not going to provide the type of long-term relief that I suspect plaintiffs are seeking here, he added. Instead, Rosenberg suggested employees take their grievances to the Merit Systems Protection Board, MSPB, an independent agency that handles federal employment disputes. Interestingly, an appeals court recently upheld President Trump's right to dismiss a Democratic MSPB member, which Rosenberg cited as precedent. This is merely the administration trying to carry out its policy objectives, he explained, acknowledging the tough personal impacts but emphasizing that remedies are available through proper channels. On the other side, Danielle Leonard, attorney for the unions, insisted Congress's intent was crystal clear, urging agencies to void the RIFs entirely. Congress could have just said, "Stop." They went further than that, she noted, stressing the public good in restoring jobs and providing stability. She highlighted the severe hardships: evicted employees scrambling for housing, piling up unpaid bills. We have seen agencies exploit their lack of communication to keep employees in the dark. There absolutely has been harm, Leonard said, underscoring how this isn't just about paperwork, it's about human suffering. Union leaders echoed this sentiment. AFG National President Everett Kelly hailed the ruling as another victory for federal employees and for the rule of law, criticizing the administration's actions as a troubling pattern against workers and the public. Similarly, American Foreign Service Association President John Dinkelman called the layoffs unlawful, vowing to fight for respect for foreign service professionals. But here's the controversy that might divide opinions. Is the judge interpreting the law correctly? Or is this an example of judicial overreach into executive decisions? Some might argue the administration is simply trying to streamline government operations in tough economic times, potentially saving taxpayer dollars. Others could see it as a blatant disregard for congressional mandates. And this is the part that sparks debate. What if these layoffs were meant to cut waste? Could reinstating everyone lead to inefficiencies down the line? If you're following changes in the federal government and want to discuss this further, feel free to email reporter Jessica Heckman at jeckman@federalnewsnetwork.com or contact her on Signal at jeckman.29. What are your thoughts? Do you side with the judge's push to protect jobs? Or do you think the administration deserves more leeway in managing staffing? Is this a fair enforcement of the continuing resolution? Or could it complicate government reforms? Share your views in the comments. We'd love to hear differing perspectives and keep the conversation going. Copyright 2025 Federal News Network. All rights reserved. This website is not intended for users located within the European Economic Area.